The judge barely looked up when he fined me $25,000 for non-compliance. I didn't argue. I didn't raise my voice. I just handed him a sealed envelope. By the time he read the first page, the courtroom went quiet. By the time he reached the last, the fine wasn't my problem anymore. I'm not a dramatic man. I'm a structural engineer. I work in load paths, tolerances, soil reports, and compliance matrices. I like things that are measurable. I bought my home in Cedar Ridge because it was quiet, edge of the community, near the retention basin, enough room for a detached workshop behind the house. Everything I built back there was permitted. Stamped drawings, county inspections, fire clearance approval, HOA Architectural Committee sign-off. I kept a binder for it, tabbed, dated, cross-referenced. I learned early that documentation saves you from other people's interpretations. The HOA president introduced himself 3 weeks after I moved in. His name was Martin Hale. He had the posture of someone who'd spent years being listened to and the tone of someone who expected it. He didn't knock so much as press the doorbell and immediately begin speaking when I opened it. "Just making sure the new homeowner understands our standards," he said, smiling without warmth. "Cedar Ridge maintains property values through strict compliance." I assured him I had read the covenants, twice. He nodded but glanced past me toward the backyard. "We've had issues with modifications." I told him everything I was building had county approval and HOA pre-clearance. He seemed surprised that I used the word pre-clearance. "Good," he said. "We'll keep an eye on it." He began visiting every few weeks, always unannounced, always framed as concern. Just making sure the structure matches what was submitted. Just verifying drainage compliance. Just checking visual conformity. He'd walk the perimeter fence line slowly, hands clasped behind his back, studying my workshop like it was a suspect. I followed the rules, meticulously. Neutral exterior paint approved by the committee. Setback measured to the inch. Sound insulation installed to meet decibel restrictions, though my tools rarely ran past 6 p.m. anyway. Still, letters began arriving. Minor violations. Possible exterior finish deviation. Unverified window reflectivity. Improper temporary material storage. Each one carried escalating language. Fines, liens, suspension of community privileges. I responded to every notice in writing. Attached photos, attached permits, attached timestamps. He stopped emailing, started taping violation slips to my door. The tone shifted from procedural to personal. One evening, I stepped outside to lock up the workshop and found him standing inside my side yard gate. Not forced entry, just unlatched. "You can't be in here," I said calmly. "It's a compliance check. HOA leadership has right of access authority for visible property elements. You're inside my fenced yard." He studied the workshop siding, ignoring me. "If you've got nothing to hide, this shouldn't bother you." That was the first moment I felt the pressure change. Not annoyance, not irritation, pressure. I installed cameras the next morning. Not because I planned to use them, because I had learned in my profession that structural failure rarely happens without warning. It happens when small tolerances are ignored until something shifts. Martin Hale had begun to shift. 2 weeks later, I received notice of a formal compliance hearing. Allegation: unapproved structural modification and obstruction of HOA inspection. The language was sharp. The fine schedule attached was not symbolic, it was aggressive. I attended the hearing with my binder. He didn't look at it. The board voted to escalate the matter to municipal court for injunctive relief. That was when I understood this wasn't about siding or setbacks. It was about authority. And he was about to cross a line he didn't understand. The morning they came onto my property without notice, I was at work. I received the alert from my phone at 10:14 a.m. Motion detected. Backyard. I opened the live feed. Martin was there, with 2 members of the architectural committee. They had opened the gate. One of them carried a clipboard. Martin was pointing at my workshop door. They tried the handle. Locked. He stepped back and spoke to someone off camera. A 4th figure appeared. Maintenance contractor. Bolt cutters in hand. I didn't feel anger. I felt clarity. The cutters snapped the padlock. They entered. They moved through the workshop, lifting tarps, photographing tools, opening drawers. At one point, Martin tapped the electrical subpanel with a pen and shook his head as if confirming something he already believed. The entire entry lasted 12 minutes. They left the door ajar. I did not confront him that day. Instead, I downloaded the footage, backed it up, sent it to my attorney. Yes, I have one, because 10 years ago I served as an expert witness in municipal construction disputes. I learned how quickly regulatory authority can be misapplied when someone confuses position with power. My attorney filed 2 things immediately: a police report for trespass and destruction of property, a motion to dismiss the HOA's municipal court complaint based on unlawful evidence gathering. 3 days later, I received notice that the HOA had added additional penalties, citing confirmed internal code violations. They referenced observations from inside the workshop, which they were not legally permitted to enter. They believed they were protected by the HOA covenant clause, granting inspection rights. They misunderstood it. The clause allowed visual inspection of exterior elements, not forced entry, not property damage, not interior searches. I attended municipal court quietly. Martin represented the HOA. He was confident. He presented printed photos from inside my workshop. He stated I had obstructed lawful inspection and failed to comply with community standards. The judge reviewed the HOA's complaint first, then turned to me. "Are you contesting these violations?" "Yes, Your Honor." I submitted my binder, permits, inspection approvals, architectural sign-offs. Then I submitted something else, a flash drive. The courtroom watched the footage. Timestamp visible, bolt cutters visible, entry without consent visible. Silence expanded across the room. The judge paused the video halfway through. He looked at Martin. "Did you authorize this entry?" Martin shifted in his suit. "It was a compliance inspection under HOA authority." "Was there homeowner consent?" He hesitated. The judge resumed the footage. When it ended, he removed his glasses slowly. The fine he had been prepared to impose for non-compliance sat printed in front of him. He folded it in half. "This matter," he said carefully, "has shifted." He dismissed the HOA complaint. Then he referred the trespass report for review. Martin's confidence drained in real time, but the collapse hadn't been scheduled yet. It had only been scheduled. If you enjoy the video, please subscribe. The special HOA meeting was called 2 weeks later. Word spreads quickly in contained communities. Trespass allegations, police inquiry, court dismissal. Neighbors who had once shrugged at violation letters now looked uneasy. I attended with a single folder, organized, tabulated. The meeting room filled beyond capacity. Martin opened with procedural remarks, but his voice lacked its usual sharpness. Then the floor opened for discussion. I stood. No raised voice. No theatrics. I projected still images from the footage onto the screen. Timestamp, entry, bolt cutters. Then I displayed the HOA covenant clause regarding inspection rights. Highlighted the limitations. Then I displayed the police report number. Then the court's dismissal order referencing unlawful entry. You could feel the shift in the room. Not outrage, recognition. A retired attorney in the third row asked Martin directly whether the board had voted to authorize forced entry. They had not. A contractor in the back asked who would cover legal fees if litigation proceeded. Silence. Within a week, Martin resigned as HOA president. The board voted to initiate an internal review. The district attorney's office declined to pursue criminal charges contingent upon restitution and formal acknowledgement of trespass. Restitution included replacement of the cut lock, payment of my legal fees, formal written apology, amendment of HOA inspection procedures. A civil settlement followed, modest, precise, documented. The financial penalty wasn't enormous, the reputational one was. In the final court appearance to formalize dismissal of residual motions, the judge looked at me differently, more carefully. He had reviewed my professional filings attached to the record, my prior expert testimony, my licensure. "Mr. Carter," he said, "I assume you understand regulatory boundaries." "Yes, Your Honor." He nodded once. So should everyone else. That was the moment Martin realized who he had tried to intimidate. Not a rule breaker, not a defiant homeowner. A man who understood systems and how they fail when misused.